Can spoken words alone land you an assault charge in Canada? People use the phrase verbal assault all the time to describe a nasty argument, but under the Canadian Criminal Code, that term doesn't actually exist. The Criminal Code is a highly specific, rigid set of definitions that determines what constitutes a crime. While you won't be charged with verbal assault, assuming your words carry no criminal liability is a dangerous mistake. Specific types of speech have their own dedicated, heavily penalized sections in Canadian law. Any criminal conviction requires two foundational blocks: the physical act, or actus reus, and the guilty mind, or mens rea. In Section 265, Basic Assault, the actus reus specifically requires applying, attempting, or threatening physical force. The mens rea, or intent, is what separates a crime from an accident. If you inadvertently bump into someone on a crowded bus, there is no crime. But if you intentionally push that same person in anger, you have the guilty mind required for an assault conviction. Therefore, angry words alone cannot trigger a basic assault charge. They must be accompanied by a physical act or a gesture demonstrating your immediate ability to apply force. However, physical gestures aren't the only way to break the law. Under specific statutes, the spoken word itself satisfies the requirement for the physical act. Section 264.1 outlines the offense of uttering threats. Explicitly telling someone, "I am going to hurt you," is an independent crime, carrying a penalty of up to 5 years in prison. To figure out how the courts evaluate a speaker's intent, we look to the legal precedent set by a case called R. v. McRae. In that ruling, the court clarified that the Crown does not have to prove the victim was actually terrified by the threat. They only need to prove that the speaker possessed the mens rea, or intent, to intimidate them. The courts rely on what's known as the reasonable person standard. Guilt is determined by whether an objective, reasonable individual would perceive those spoken words as a threat in that specific context. Under Section 264.1, the crime is complete the moment the threatening words leave your mouth. The victim's emotional reaction is legally irrelevant to the conviction. But what happens when the words used aren't explicit threats of violence, but instead form a repeated, distressing pattern? Section 264 defines criminal harassment. If a person knowingly or recklessly engages in communication that causes someone to reasonably fear for their safety, they have committed a distinct crime. This chart shows the maximum sentence severities for these offenses. While basic assault and uttering threats cap at 5 years, the maximum penalty for criminal harassment jumps to 10 years in prison. Another boundary is intimidation under Section 423. Using threats of violence to force someone to act, or to stop them from acting, represents a further legal escalation. A single, isolated physical altercation is serious, but the law punishes psychological manipulation and coercive speech patterns just as strictly. The boundary separating a legal, heated argument from a criminal act is firmly established by the Criminal Code. It comes down to 3 controlling factors: the speaker's intent, the presence of physical gestures, and how a reasonable, objective person would interpret the exchange. The Canadian legal system does not view aggressive words as harmless venting. The statutes enacted by Parliament treat targeted, malicious speech as a severe public danger. A momentary lapse in emotional control during a verbal dispute can instantly cross the legal threshold, resulting in a permanent criminal record. The boundary between words, physical gestures, and intent carries severe statutory penalties. If you are dealing with threat allegations or require legal representation under Canadian criminal law, contact Paxlaw Corporation at paxlaw.ca.